The other members are Mr. Waithaka Garuya, an advocate practicing in Nairobi, Mr. Bahati Mamuye, also in Nairobi, and Dr. Kariuki Mwigwa. Dr. Kariuki Mwigwa, I think, needs no introduction and is known to most of the lawyers present. Our CEO is Belinda Akelo, and we have a secretariat at Popo Road in Nema. Popo Road is where the former is the road where, in South Sea where the former Bellevue cinema used to be. So the registry is situated there. We also have a court in at the same premises, which has been active for many years when there were physical hearings. At some stage, we were moved to Reinsurance Plaza, where we also have a court at Reinsurance Plaza, and physical sittings were normally done there. However, since COVID, the onset of COVID, technological changes forced the tribunal to go virtual, and most cases are had on a virtual basis. Now, what is NET and what is National Environment Tribunal? I think this is a question many members of the public confuse, and sometimes even lawyers confuse. They usually equate the National Environment Tribunal with being the NEMA tribunal. This is a very common misconception that somehow NET is a NEMA tribunal and that we are a part of NEMA. That is not true. And by way of clarification, the National Environment Tribunal is an independent body set up under the Environment Management and Coordination Act, that is EMCA, under Section 125. It is independent from NEMA, but tied to the decisions of NEMA, in that it is an appeals body that hears decisions from NEMA and makes determinations on those decisions. So, of course, that jurisdiction is found in Section 129 of the Act. And that jurisdiction covers, firstly, the appeals from licensing issues, licensing being issuance of national environmental impact assessment licenses or refusal to issue environmental impact assessment licenses, or anything else starting with licenses are covered under Section 129.1, where the jurisdiction comes from. Section 129.2, 1A and 1B, and then what it does is that it also grants jurisdiction to the tribunal to hear decisions other than licensing requirements, things that NEMA make decisions on or are expected to make decisions on, which then they either through a positive act do. That includes, let's say, closure notices, improvement notices, in which case the tribunal is mandated to hear whether that was merited or not. We are also mandated to hear negative decisions, which include failure to act. So when there's a complaint about music in a neighborhood, and someone writes to NEMA and asks them to do something and they don't do something about it, or they write back and say we won't do something about it, then jurisdiction is also conferred on the Environment Tribunal to make a determination on whether that is merited or not. And that refusal can be, or the refusal to make a decision can be either through a written response or through inaction. So the tribunal is quite vibrant, and its jurisdiction allows it to do a lot of things. Now, unknown to many people, it is not only under the Environment Management and Coordination Act that that the tribunal also has jurisdiction. So other statutes that the tribunal gets jurisdiction from are the Kenya, the Forest Management and Coordination Act, where decisions from the Kenya Forest Services come before us. Then there are decisions under the Wildlife Conservation Statutes, the Wildlife Conservation Management Act, where there are issues of compensation as a result of harm, or damage, or injury caused by livestock. And those decisions are sent to the wildlife conservation committees, the ministerial wildlife conservation committees in the various counties, and those committees make a decision. Then parties are entitled to approach the tribunal and appeal those decisions. So that is the basic mandate of the tribunal, to deal with environmental matters under EMCA and to deal with forest disputes and the forest statute and wildlife conservation compensation decisions under the Wildlife Compensation Act. I hope that gives an overview of the tribunal's work and where they're situated.
All right. Thank you so much, Mr. Balal. I really appreciate that. I find it very interesting when you say that, when you mentioned the failure to act, that one can approach the tribunal. Now, maybe just to clarify, how does one approach the tribunal? Do we file? What kind of documents do you expect us to file? Do you have an online registry like the one we have at for civil and criminal matters? And then how do we expect the hearing to go, and what are the procedures for carrying out a hearing at the tribunal?
Yes. Yes, Victor. Yes, we do have a registry. As I said, the physical registry is at Popo Road. There's a registry, a court that is situated there. And in addition, parties are encouraged to also file online. So if you go to the National Environment Tribunal website, you will get the physical location as well as the email location or the email address of the tribunal. So parties are encouraged, whenever they're filing, they file both at the physical registry and at the on the online portal. Now, the importance of filing is because of the time. The jurisdiction of the tribunal is curtailed by law with respect to time. So you will find a situation where the National Environment Tribunal has no regional restriction. So we're a countrywide tribunal. We hear decisions from any part of Kenya. In addition, we have no pecuniary limitations, so that we are able to entertain disputes of low value and others of values in billions. So projects, and mainly it's projects or other such matters. So the only curtailment, and the primary curtailment, is the time. And because decisions have to, or appeals have to be filed to the tribunal within 60 days of a decision of the National Environment Management Authority, either through the license, refusal to grant a license, or any other decision, is 60 days. What documents do you file to the tribunal registry? You file a notice of appeal. It is because what you're doing is we are exercising an appellate jurisdiction as the National Environment Tribunal. It is an appeal from a decision of a public body, that is NEMA, an administrative decision, essentially. So that it is a notice of appeal. In the notice of appeal, there is a format set out, and as much as possible, there's encouragement towards simplicity, not to make too complicated, because you have a lot of lay people coming and filing appeals themselves. And so we're not saddled by technical issues or technicalities. There's no undue regard to technicalities. As long as there's a notice of appeal, it identifies who the parties are, it identifies the decision you're challenging and the grounds upon which you're challenging them. And of course, when you're doing so, you're required to file your bundle of documents in support of your appeal or your grounds of appeal. And many times, people file even appeals in Swahili. So you could file parties, well, not lawyers, but parties in person coming and filing an appeal in Swahili. And they will not be turned away, because essentially the only thing that restricts the tribunal's jurisdiction is the time factor. But with respect to everything else, there's a lot of flexibility. So that is how filing of appeals are done. Once it is filed, the notice of appeal is then given a mention date. There's a requirement for service of the notice of appeal and other appeal documents. We have procedure rules, the National Environment Tribunal Procedure Rules of 2003, which set out what an appellant has to do, including service upon respondents. But we do give a mention date at the initial filing so that it comes up for directions as regards service, to confirm service has been effected, to give directions as to when a response should be done, etc., etc. So that is the basic technicality. And hearings are done virtually. Presently, they are done virtually. We were one of the first bodies, in fact, to adopt the virtual hearings very early on during the COVID restrictions. And that has continued to date.
Thank you for that, Mr. Balala. Just another question on that issue of procedure. And now it's good to know that it's an appellate jurisdiction that you exercise. Now, yes. Once a decision is rendered by the National Environmental Tribunal, where do we expect to find these decisions? Are we able to access them from maybe your website, or do we access them from the Kenya laws?
Yes, because of COVID restrictions, initially decisions were being rendered in person, I mean, when the court was sitting physically. However, since the COVID onset, decisions then would be rendered virtually. Because of the number of cases that were coming up, there's a high number of appeals being filed. So a lot of time, decisions would then have to be just sent out to parties. So they are sent out by email in soft copy to allow them to have the decisions early on. And these decisions are then also put in the website, the organization website, the National Environment Tribunal website, but can also be found in the Kenya law reports. So the Kenya law reports have a section for tribunals, and you will find the National Environment Tribunal's decisions are within that category in the Kenya law reports. Yeah, they can be found there.
Well, that's really wonderful. And now, just now to the last part of maybe your presentation. For the lawyers that are on board currently, what opportunities are there for lawyers are those in that particular tribunal? My question is specifically, do you see a lot of lawyers practicing in those tribunals? And does that then mean there is a lot of opportunity for them to practice in those areas? And maybe how can they get referrals for matters that would probably proceed to the National Environmental Tribunal? Thank you.
I think there are a lot of opportunities for lawyers in the tribunal. The reason is that for a long time, the tribunal's work was very low, the workload was very low, because many lawyers were not filing at the tribunal. But with increased information, more lawyers are now coming to the tribunal. And the tribunal is a place where a lot of lawyers, many senior lawyers also, are appearing before us because of the magnitude of cases. As I said, the tribunal matters before us are not restricted in any pecuniary or regional way. So that there's a lot of opportunities for people to file there. How do they get matters? Well, everything in this country, at the end of the day, is subject to the environmental laws. And everything has an environmental impact. So there are many people in very different and wide areas of our lives, always affected by certain decisions being made or lack of decisions being made when they're required to be made. But because of lack of knowledge of where to go, so you find many Kenyans complaining that certain things are not being done, certain steps are not being taken, not because there's no law that provides for them or nobody, but it is because nobody has explored that opportunity. As a tribunal and a body, we can't go out and advertise ourselves. We also don't have jurisdiction to commence matters suo motu. We actually have to be moved by somebody in order to make a determination. So if someone is dumping rubbish outside your house, if there's a bar next door to you and it's not supposed to be there, then we can't close it down, nor can we order anybody to remove the garbage outside the door until somebody moves the tribunal. But as I said, because we're an appellate body, somebody has to first approach the authority itself in charge of the environment, which is NEMA. And if NEMA refuses or fails to act, then you can approach us. And there's wide opportunities. So it ranges from something as mundane as something as noise and garbage being dumped outside your house to more technical issues like base stations, pollution from base stations being set up in a residential area, to electric lines, to construction of developments, infrastructure, and other things, factories being operated. It is a very, very wide area. So there's a lot of opportunities that I think many people would appreciate and follow. Now, luckily, because we're a tribunal, we are not the final port of call, so that all our decisions are subject to challenge before a higher court on appeal when we make a mistake, or if someone feels aggrieved by our decisions. So that opportunity is always there. It is exercised by the lawyers who appear before us on many occasions, sometimes successfully and sometimes not. But it is a right and an opportunity that's given to them. Now, why would someone come to the National Environment Tribunal and not to any other court? The reason is because of the Fair Administrative Actions Act has now provided, or has provided for some time, since 2005, that all matters have to commence, or there has to be the exhaustion of remedies. So the exhaustion of remedies has to start at the body that has been set up to deal with those issues. That matter has been determined up to the Supreme Court. There's a decision in Kibos Sugar in the Supreme Court, which has now set out. This is a matter that came out from the environment. It was a challenge to an environmental impact assessment, where someone filed to the ELC, and the matter went to the Court of Appeal up to the Supreme Court. And the Supreme Court has now clarified or set out the law as it should be, that courts will not entertain, will be very hesitant to entertain any challenge where it involves environmental matters in the MCA, unless they've exhausted the path through the National Environment Tribunal. So I think that's something that even as lawyers, we should be aware of. Yes, Victor.
Thank you so much for that. Just two more questions. Number one, when you talked about the whole spectrum of what the National Environmental Tribunal tackles and the opportunities for lawyers there, my question would be, for a lawyer who wants to specialize in environmental matters, what would you advise them to study on, or where would you advise them to do their reading? Is there like a master's that they can do, or a kind of specialization that they can do so that they can get more specialized in that area?
Yeah. Of course, presently, there was a time when environmental law was not a subject that was taught in schools, but with greater progress, greater attention to the environment from the 1990s going forward, now courses are being offered in environmental law, whether at undergraduate level or at master's level. So it is something that is worth taking up. It is a very good area of law to consider, because it covers, as I said, the environment, touches every aspect of our lives. And there's a lot of opportunities in the study of environmental law. Many lawyers that we know of are also environmental impact assessment or environmental impact experts, because those are registered experts under the Act. So you apply to NEMA. If you have the qualifications, they will register you. It allows you also the opportunity to prepare reports, environmental impact assessment reports, or to question them as such. but it equips you with the knowledge and the skills to come before tribunals and courts in submitting on environmental matters. Is it a necessity to have an undergraduate or a master's in order to do so? No, it isn't. Because as lawyers, we're very versatile, flexible, we're able to adapt quickly to certain areas of law if required. It is just a question of reading the Constitution of Kenya. The Constitution has adopted international standards on environmental law. It's there. Environmental protection is a constitutional right under our Constitution. The Environment Management Coordination Act is a code of some sort of the entire environmental law we have. So it's a question of reading through the act and the regulations, because you have tens of regulations that govern different industries and different aspects. So lawyers are best equipped when they read them and then understand them. And coming back, let's say, to the example of noise pollution, for example, those are already governed and regulated under the environmental regulations, which has set out standards of noise pollutions, whether it's in a residential area, in a commercial area. So lawyers have that opportunity to go and read widely on such things. And that's the literature they should be looking at. And that will be equipment in coming before the tribunal or any other environmental court.
All right, so the last question, what circumstances would a decision of NET be challenged in court? What circumstances usually arise?
Well, at the end of the day, members of the tribunal are human beings. So there could be error in facts or error in law. Essentially, we do not pretend to know everything. And in fact, we are happy in many occasions when someone does appeal something, because it gives a guideline also to the tribunal as to what is the correct course to have been taken or to be taken in certain matters. A lot of appeals go based on facts, on law, and in questions of jurisdiction, because jurisdiction is a very big deal within the tribunal as regards the 60 days, the computation of time, whether the tribunal has the right to extend time. And those matters have already been determined by higher courts, because people have appealed based on those things. And we have, as a result of those appeals, which have been appreciated, they have given us guidance as to which way we should go. How do we compute? What powers do we have and what do we not have powers to do? So those are all important aspects. And I think the appellate process to higher courts for more decisions is something that is indispensable and actually very encouraged, because it is a way of checking against any wrong decisions or mistaken decisions that may have been made. Of course, being with a panel of 5, there's an effort to have 5 heads looking at something. And under our rules, we are permitted to have dissenting decisions, which we have done on very rare occasions, because most of the time there's a lot of consensus and a lot of discussions, conferencing on matters. So decisions are usually unanimous, but in some occasions, there is dissent in decision, and that is perfectly okay, just like in any other court. And if somebody is still aggrieved, there's still opportunity to appeal.
All right, thank you very much for that. I really appreciate the comprehensive analysis that you've given for us. I think we have a much better understanding, and we now have a lot of reading to do to get more understanding about how we can practice in that area. So I'd just like you to remain on board as we listen to our other panelists, and then we will tackle the general questions afterwards. So I'm kindly going to request Mr. Ramadan.
Sorry, Victor, I can't hear you.
Sorry, my apologies. I'm saying, so for Mr. Ramadan, who's the Communication and Multimedia Appeals Tribunal, to give us also an analysis of what the multimedia and the Communication and Multimedia Appeals Tribunal is, and so that we can learn more about it. So over to you, Mr. Ramadan.
Thank you, Victor, and thank you for inviting me for this session. CAMAT, what we usually call it, is the Communications and Multimedia Appeals Tribunal. We are established under KICA, which is the Kenya Information and Communications Act, under Section 102. And under this act, we have 7 members, a quorum of 7 members, but as of this moment, we only have 5 members due to the expiry of the term for the 2 members. We have a chair who is appointed by the Judicial Service Commission, and the rest of the members are appointed by the Minister for ICT through a competitive process. As of this moment, the 5 members who are, I wish to name them, the chair is Rosemary Kuria, who also sends her apologies. She couldn't be with us today, but I'm here holding her brief. The other member is Captain Collins Wanderi, who is a lawyer of tremendous experience in matters communication. And we also have Vivian Atieno, who is a communications expert. We have also Damaris Nyabuto and myself. I'm a lawyer. Therefore, you see the tribunal is composed of members with different experiences for purposes of rendering decisions and determining matters which sometimes are of quite a complex nature. Matters concerning technology, communications, courier services, radio communications, licenses, freedom of expression. Having a look at KICA, you find that a person can approach the tribunal if he or she is aggrieved by any publication, perhaps by a journalist or a media enterprise, or where you find that a journalist has written something about you and you find it to be defamatory, you can approach the tribunal. Or you find a media enterprise has made an advert outside the watershed hours, you can approach the tribunal. Or where you find that maybe a government body has done something which is against the constitutional right of freedom of expression, you can approach the tribunal. Or a scenario where a decision has been made by the Communications Authority or the Media Council, you can also approach the tribunal. If it's from the Communications Authority, it has to be an appeal. Yeah, perhaps let me mention that we have original and appellate jurisdiction. So where there's a complaint against a journalist or a media enterprise, then that should be the original jurisdiction. Where it's appellate, it's maybe from a decision made by CAMAT, or a decision made by the Communications Authority or the Media Council. Then, of course, the appeal must be filed within 60 days. Yeah. And if you wish to appeal from a decision of CAMAT, that is the tribunal, then that appeal to the High Court is within 30 days. A complaint before the tribunal can be oral or in writing. And if it's made orally, the same has to be reduced into writing within 7 days by the Secretariat at the tribunal. Well, I also have to mention that the complaint has to state the grounds, the nature of the injury, and the remedy that is being sought from the tribunal. There are several orders that the tribunal can issue, considering the grievances that are brought before the tribunal. And one of them is that the tribunal can order a particular media enterprise to issue an apology or a correction of the facts from the complaint, of course. The tribunal can also order for a return, repair, a declaration. Can order a return, repair, or replacement of an equipment which perhaps has been damaged by another party. That is, of course, a communication gadget or anything, perhaps a camera, anything. Yeah, concerned during one's, maybe a journalist's workings. The tribunal can also order or make a declaration on matters freedom of expression. It can also issue a public reprimand to a journalist or a media enterprise. And of course, even cancellation of a license of a journalist. Yeah, also a fine, but the fine cannot exceed 20 million on a media enterprise and 500,000 on a journalist, on any journalist, yeah. Well, we can also issue a criticism on any party before us, and of course, suspension from the register of journalists, and of course, any other order that the tribunal deems fit. I think basically that is the structure of the tribunal. We are based at Forodha House, that is 4th floor, right next to the Milimani Law Courts. Filings to the tribunal are online. I believe also we are on the e-filing platform. We also have an email address, which is kamat@court.go.ke. I repeat that, which is kamat@court.go.ke. Matters before the tribunal are basically, what should I say, are not expensive in terms of costs. In terms of the figures, what someone can spend from the start to the end of a matter would be around 5,000 shillings from the filing to judgment, because filing is about 1,500. Then the other requisite fees that may be paid upon filing. I think that's that for now, unless there's something else, Mr. Victor.
All right, thank you, sir. Thank you, Mr. Ramadan, for that. Now, I know you've mentioned that the tribunal has both appellate and original jurisdiction. So in a situation where the communication authority has failed to act on a particular issue or has refused to act or rule on a particular issue, is that one of the areas where someone can appeal to come out for direction or for relief?
The communication authority must have made a decision for you to approach us. And of course, it must be within the timelines, that is the 60 days of that particular decision through a memorandum of appeal. And once you file the particular document, then the communications authority will also have an opportunity to file a statement of facts responding to your challenge. And perhaps to mention, there are rules to govern this. That is the appeal rules of 1999 under KICA. So indeed, if a decision has been made by the communications authority, then there is a right to challenge. And perhaps to mention, recently, there was a decision that was made. You will recall matters concerning the call rates. I don't know if you had a chance to have a look at that. Perhaps members on the platform may have seen that, where the call rates a directive was issued by CA on the call rates against the telco companies, and they approached the tribunal and a consent was made, and that is in public domain. So indeed, yes, one can approach the tribunal once a decision or a directive has been issued by CA.
Thank you for that. My other question would be, where someone is aggrieved by a media house or a journalist in as far as a statement or a production that was defamatory in nature or libelous in nature, approaching CAMAT for relief, does that take away your right to also file in civil court for defamation? Is it in addition to?
Yes. Yes, I don't think it does. For these reasons, this is my view. Of course, it's other members may have a different opinion. So this is just my personal opinion on the same. I don't believe it takes away the jurisdiction of the other courts. For this reason, the tribunal does not have powers to issue damages. We can only reprimand the particular media house or journalist who's aggrieved the complainant before us. So therefore, that would mean that for us is to make a decision against the particular journalist only. But matters, damages, of course, that's for the courts, the law courts, to make a finding on. So I don't think it takes away the powers of the judiciary as we know it.
Thank you, Mr. Ramadan. In addition to that, maybe you can help us understand, for lawyers that are on the platform, what opportunities are there for lawyers to practice in that tribunal? Do you see a lot of lawyers, bringing their clients' cases to the tribunal, or you still don't have that traction that we have seen maybe from the National Environmental Tribunal as per our previous panelists?
There are tremendous opportunities for lawyers. I begin by stating maybe perhaps an opportunity for one to be a chair of the tribunal, a member of the tribunal. There are also opportunities, just to mention, members have a term of 3 years. So sooner or later we'll be out, then other members of the public and lawyers will have opportunities to serve the tribunal and serve the nation. In terms of parties that appear before us, most of the parties are telco companies, even media houses. So you find these opportunities for lawyers to represent the clients, the telco companies and others. So there are tremendous opportunities, even to specialize in matters telecommunications. I don't know, I'm not sure there's any university that offers LLM on this, but I know of Queen Mary University that offers LLM in matters telecommunications law. And after perhaps one gaining expertise on this, one can serve as a regulatory officer in most of these big companies, or even as a consultant. So matters telecommunication and licensing are quite complex. So if one gets an understanding of KICA, the act itself, because you'll find, if you have a chance to perhaps skim through it, you'll find there are quite complex issues in terms of licensing and broadcast and everything. So there are tremendous opportunities when one understands the processes in matters communication. Yeah.
All right. Thank you very much for that. Now I'd like to just open up the session to the plenary and ask my fellow colleagues to ask questions to these wonderful gentlemen that are here, representing their various tribunals. So I'd kindly request that you can raise your hand, and then I will ask you to maybe pose your question, and then you can direct it to either of the two gentlemen, and then we can proceed to the next session. So let's have members asking questions. Do you have anybody with a question? You can put up your hand. You can raise your hand. So there's a question here by Sophie Chirchir. I think this is a question to the National Environmental Tribunal. In case of injury or loss from wildlife, does it mean one can first approach the tribunal in search for damages before going to court? I don't know whether Mr. Balala is still on board. You can answer that question.
Yes, Victor, I'm still here. Just repeat the question, please.
The question is, in case of injury or loss from wildlife, does it mean one can first approach the tribunal in search for damages before going to court?
No. The answer is no. What happens in case of injury or damage by wildlife? The first step is what we call the Wildlife Conservation Compensation Committees. These are set up under the Act. And one then goes to lodges a claim with them within a specific time that's provided for in the Act. And upon the Wildlife Conservation Compensation Committee refusing the decision or making an award different from what the person felt they should get, then an appeal is lodged to the National Environment Tribunal. Now, there's a schedule in the Act, in the Wildlife Management Act, as regards the level of damages and awards compensatable. So different animals, injury from different animals have different awards, minimum awards. So I'd encourage members to also look through the Act and the schedules to see that. And this is usually being updated. The schedule is always being changed. And so there are different awards and at different times, different things, different awards will be provided for. I hope that answers the question.
Yes, it does. Yes, it does. And that's a very interesting look at that. All right, so we have a question by Carol Kiare, of course, who is a member of the Secretariat at LSK. So the question is to Mr. Ramadan, how does one approach CAMAT? How do we file our documents? I know you mentioned before that if it's an appeal, you have to approach the tribunal with a memorandum of appeal. So maybe you can clarify a bit more on that.
Yeah, indeed, if it's an appeal, it has to be through a memorandum of appeal. It's important to mention that the memorandum is not as per the usual memorandum as we know it. This one has to be accompanied by a statement of facts where you get to also annex the evidences that you wish to rely on. So it comes as a bundle. It's like you're filing a plate, but it's titled a memorandum of appeal where you narrate your grounds and under the facts, then with a statement of facts, then perhaps, or even your witness statements, even because the appeal can be heard orally through calling the witnesses or via submissions. If it's a complaint, it can be one can approach the tribunal either orally or in writing. We are in the process of formalizing our rules. The previous tribunal had a chance to conduct public participation. We are only remaining with Nairobi. So in the next few months, we'll be conducting public participation on our rules, and perhaps you can even share the draft rules with the Secretariat LSK Nairobi to share with the members, just to have a look so that we can develop the rules in matters guiding filing and the format that one can use when approaching the tribunal. But as of this moment, one can do it orally and in writing. So there's no specific legalistic technicality on the same in matters complaint. But in matters appeal, we have the appeal rules 1999 to guide us.
All right. Yeah, of course, the rules that were passed in 1999 seem like they need to be updated. All right, so yes, for Mr. Balala, maybe a question that maybe you did not tackle. What are the rates for filing when one is approaching the National Environmental Tribunal? Do we have a schedule of costs for that?
No, as part of environmental law principles, which means that there has to be access to justice. Environmental law principles are found within the Rio Declaration. And one of those principles is that there should be access to justice. As part of that principle, there is no filing fees. There's no filing fees before the tribunal. It's free of charge till today, despite a lot of lobbying and movement that we should have fees. I think the overwhelming view is that the tribunal should not charge fees until now. So unless there's any changes later, legislative changes, to date, there are no fees charged for filing.
Thank you for that, Mr. Balala. Over to Mr. Ramadan. Does CAMAT handle the infringement of intellectual property, more specifically copyright matters?
No, we do not. We do not have jurisdiction for such matters. We will immediately strike it out.
All
I
right.
believe under the Copyrights Act, there is a tribunal established for that. And matters intellectual property, there is also a tribunal, or is it a board? There is for both. Yeah.
Yes. So Irene Thuku, there you go. If you have an intellectual property matter, specifically copyright, please approach the tribunal under the Copyright Act. All right. So I think for Mr. Ramadan, he had already spoke to us about how long. No. He just mentioned how much it costs to file a matter at the tribunal at CAMAT. So for both tribunals, we can start with Mr. Ramadan. How long does it take to hear a matter, to get it fully concluded? Assuming it's not, okay, you can maybe start from the point of a matter is dismissed preliminarily at the earlier stages, summarily maybe, and then maybe it goes to a full hearing, and then you have to render a decision. So how long does that take, generally?
Generally speaking, for matters that we have dismissed summarily, we have tried to do this within 3 months. This is because immediately a matter is filed, the same is shared by the Secretariat to the members, and directions are issued for parties to approach, and directions on pretrial are issued. So within 3 months, one would get a ruling if it's to strike out the matter. And if it's a memorandum, let's say an appeal that is canvassed via written submissions, roughly within 6 months. If it's a matter that would go for hearing where parties would need to call witnesses, I can say 6 to 12 months. 6 to 12 months, I can say, but from the time we were appointed as members, because all of us were freshly appointed, we found about, I can't remember the matters, but there are over 20 matters. As of this moment, we only have six to 7 matters. So I can say you spend the shortest of time once you approach this particular tribunal. So it depends on how complex the matter is, because sometimes you might find a very complex matters, and as a tribunal we may need to perhaps have them tender their evidence orally. But roughly I can say 6 to 12 months.
All right. The same question is posed to Mr. Balala. Mr. Balala, are you there?
Yes, I'm here. Sorry, I'm having a bit of challenges with the network. What is the question?
Yes, the question is, how long does it take for the tribunal to hear a matter from beginning to end in terms of timeline?
Yes, usually the hearing, the filing takes about a month and a half because after exchange of documents. The hearing, depending on how complex the matter is, because people file witness statements and they adopt the statements as part of examination in chief. There's cross-examination. So it could take about 3 to 4 months to conclude the hearing. But decisions then are subject to consensus and conferencing. So sometimes decisions take a bit longer. Usually timelines between 6 to 8 months would be normal in order to conclude a matter. Depending on complexity, it takes a bit longer. It could take up to a year from first to last. Sometimes out of jurisdictional issues, a matter could be determined at a lower timeline.
All right. And looking at that timeline, is it possible maybe for a litigant to approach the court for interlocutory orders pending conclusion of the hearing, maybe to preserve a particular issue?
Under the Act, Section 129(4), at the time of filing an appeal, there's an automatic stay. Now, that is a stay by law. Now, many parties, at many instances, decide to also file the applications for interlocutory orders. Those are entertained and they are heard. However, they have the overall effect sometimes of delaying the fair hearing of the matter. But there's nothing stopping anyone from filing interlocutory applications. We have had interlocutory applications for injunctions, for conservatory orders. We have had interlocutory applications and dealt with applications for contempt of any orders, for discovery. So these are all available interlocutory measures.
All right, thank you for that. I can see a question by Steve Luceno. And I'm not so sure whether is referring to the Financial Administration and Audit Act, but his question is, does NET consider the FAA Act provisions as to the administrators' obligations when making decisions under MCA? Maybe Mr. Luceno, you can just unmute and clarify your question. Okay, it's not clear to me. I don't know if it's clear to Mr. Balala, but Mr. Luceno, you can maybe clarify. Go ahead.
This is Luceno. Good afternoon, everyone.
Good afternoon.
Can you hear me?
Good afternoon, Mr. Luceno.
Thank you. No, my question is, I've appeared before CAMAT. I've seen my Mr. Mukira and the entire tribunal basically referring regulators, decisions made by regulators back to them to comply with the provisions of the Fair Administrative Act in terms of inviting a party affected to be heard, in terms of notifying the party that you need to make submissions on the issue that is at hand, and basically, lastly, communicating a decision to them. The question, and I've seen this mostly in the communication, sorry, under the Kenya Communication Act, so to speak. So the issue is, I think, the Fair Administrative Actions Act deals with all the regulators, and I think that's why the decision makers then are called the administrators. So the question I'm asking the chair of NET Tribunal is, do you consider the DG NEMA as an administrator, and then is he obligated to invite parties who might be affected by his decision to be heard before he makes that decision? Are these considerations you make when you are interrogating appeals before you? I hope that yes, is clearer.
Mr. Lucero, that's absolutely clear. Yeah. Yes, if the question I understand is correctly, is whether the DG is an administrator under the Fair Administrative Action amenable to direction as to right to fair hearing. That is required to give reasons, call people if any adverse action. Our answer is yes, he is. As NET, we consider the DG or the agencies below the DG of NEMA to be organs covered by Article 47 of the Constitution and by the Fair Administrative Actions Act. That is, they are required to act in a particular way and within the law, the provisions of those laws. And if they fail to do so, then they're amenable to correction in the action or direction, or for their decisions to be suspended or cancelled altogether. This is something we have done in the past, even when there has been closure of factories, for example, without following process. We have reinstated and vacated those directions by the DG. When there has been cancellation of EIA licenses, we have, where there has been no fair administrative action, either through a right of hearing or through a right for someone to participate in such, to have reasons for the decisions, we have overturned such decisions of the DG, because we consider him an administrator under the Fair Administrative Action. Is that sufficient, Mr. Osena?
Thank you. Thank you. I think that is good for the session. Thank you. Thank you very much.
Thank you.
All right, ladies and gentlemen, we've come to the end of our session. And I'd like to thank Mr. Ramadan Mukira, a member of the Communications Tribunal, for coming on board and giving his remarks and telling us much more about the communication, that tribunal, the CAMAT. And then also to Mr. Mohammed Balala, also for telling us more about the National Environmental Tribunal. We really appreciate. I think we've learned a lot today, and our appetites are now wet in terms of wanting to find out more about these tribunals. So thank you so much, everyone, for attending. I really appreciate you taking time off your afternoon to just attend this webinar. And also thank you to Caro from the Secretariat for enabling us to attend and to organize this. So I'd like to encourage everyone to keep on looking out for what the Nairobi branch is doing. We encourage each member to subscribe as a member so that you can get some of the benefits. We've seen it in the flyers, and I encourage you to also spread the word. When we have some of these webinars, please share the flyers so that we can have a lot more people attending. But thank you so much for attending in person, and I'm sure you've learned. Please let's have your feedback on the chat, and I will close the chat maybe in the next few minutes. Thank you very much, Mr. Ramadan and Mr. Balala.
Thank you.
Thank you, sir.
Thank you everyone for attending.